So first of all, let me tell this August House that what can be more urgent than for the government to take steps to ensure the safety and security of the women. Many of the honourable members have raised that there was no requirement or urgency for the promulgation of the ordinance. I genuinely feel that when the whole nation is having this pain that our young girls, child below the age of 16 years, 12 years of age, are victim of brutal rape, then government has to rise to the occasion. Government cannot remain silent. So that is why, when the House was not in session, it was decided by the government that a promulgation had to be brought and enforced. That is why on 21st April 2018, the promulgation of ordinance was given in effect. And let me remind this August House, when the Honorable Prime Minister of India, from the rampart of the Red Fort, made the speech, he made his intention very clear that our sisters, our child, our mothers, the women of this nation must feel safe in our own country. And for that, let every parent question their sons that how are your conduct is affecting the moral of the society. So the intention of the Honorable Prime Minister has been taken forward in the form of promulgation of this very important bill, and today which we are coming out, and here all the honourable members have given their very valuable comments, suggestions. I have taken the note of all the important suggestions, and I also agree that merely making laws will not be enough. Law is necessary. Stringent legal provisions are necessary. But much more than that is how we translate those legal provisions into effect. And then what are the implementation process? How are we going to strengthen all the agencies and infrastructure there in the country? What are the requirements to make changes? These are important. And within very brief reply to this discussion, I will be mentioning all those provisions which we have made provisions therein. Before that, let me come to the provisions of the law which we have made changes. In the beginning, the rape itself, whether it's a minor or major, rape is a rape. It's a very, very shameful for a country, even if one instance of rape case happens. So it is the collective conscience of this nation. We have to come together, and this August House, this is the platform where we represent the entire nation. So this is the platform where we have to regulate, we have to make provisions. That is why in the previous provision, the punishable for the rape was 7 years. Now, under the new provision, the punishable has been enhanced to 10 years imprisonment, and which is extendable to the life. That is under the section 376 of Indian Penal Code. Now, coming more specific to the changes which we have come up with. A woman under the years of 16 years. Earlier, the provision was let me clarify. Some of the honourable members have made this point earlier also about the definition. Woman, which we have mentioned woman because as per the provisions in the Indian Penal Code, it is mentioned as woman because there is no differentiation between the mentioning of woman or girl, because rape has been defined as rape of a woman of any age. That is the thing. We are not discussing about the title and the concept here in detail. What I'm saying is the IPC has just spelled out woman of any age. So that is why let us understand that our intention is very clear. Now, if a woman who is under the age of 16 years is being raped, then earlier the punishable provision was 10 years. Now it has been enhanced to 20 years of rigorous imprisonment or rest of life. That means he will spend his lifetime up to lifetime in the jail. Those gruesome cases which is involving the woman below 12 years of age. Earlier, the provision was 10 years rigorous imprisonment, extendable to imprisonment for remainder of life. Now it has been extended to 20 years of rigorous imprisonment to death or rest of life. That means it is extendable up to lifetime. As long as he is alive, he will remain in jail. If it is a gang rape, the earlier provision was punishable with minimum of 20 years rigorous imprisonment or remainder of life. Now the new provision is punishable with death or rigorous rest of life imprisonment. So this is a very stringent provision. Now in the provision there are consequential effect also. Under the Code of Criminal Procedure, the investigation of rape cases, in earlier cases it was to be completed in 3 months from the date of FIR. Now the timeline is being reduced to 2 months from the date of FIR. The inquiry or the trials of the rape cases earlier was to be completed as far as possible within 2 months. So the intention was there as far as possible, but now we have made it mandatory. So the inquiry or the trials of the rape cases are to be completed within 2 months timeline. It is a clear-cut mandatory provision being inserted. From the date of FIR is registered. Yes. The investigation officer will come to know when only the cases are reported to him. So we can't go on that line. Earlier there was no timeline for the disposal of appeal. When a court, a lower court, gives a punishable judgment, then anybody can go to the appellate court, and there was no timeline for the disposal of the appeals. Now, sir, the new provision makes it very clear that even in the cases of appeals, it must be decided within 6 months' time. So these are very important provisions the government has come up with. And sir, with regards to anticipatory bill, many of the honourable members were talking about influential people having access to good lawyers and good legal services. They manipulate the case and they get bails. These are some of the accusations. So earlier there were no provision for mandatory, there were provision for anticipatory bail, but now the anticipatory bail is not available to a person accused of rape of women under 16 years of age. So there is no provision for bail. And sir, while the bail petitions are being heard, there are systems which we have to tighten. There were no provision of mandatory notice on the bail application by the person accused of rape of women under 16 years. Now, mandatory for court to inform the public prosecutor within 15 days of receipt of the notice of the bail application. So, under Section 439 of CRPC, the 15 days mandatory has been made. And, sir, in addition to that, there were no provision for association of the victim side during hearing of bail application by the person accused of rape of women under 16 years. Now, there is enabling provision made in to provide for representation of the victim side in the court. That means when the accused moves an application, that means the lawyer, the representative of the victim, has to be present in the court.
Minister, you have given so much elaborate explanation, what are the provisions are there. Yes. That must be publicized more. The people must have, even the rural area must know that these are the provisions. Then only there will be some kind of resistance, or they will feel it. And without publicity, just in the keep of the rule of the book, it won't help. Therefore, it has to be more publicity.
I very much appreciate, Honourable Deputy Speaker, sir, for your this advice.
All these languages, regional languages, all you have to publicize.
Right, sir. We need
the seriousness of that, then only it will affect. Otherwise, no use.
We need to create more awareness. Deputy Speaker, sir, your advice is very well taken. All the honourable members of this August House also have a bounded duty to take forward this message and the new laws and the provisions being made.
All the medias must be publicized.
Right, sir. Sir, with regard to some of the issues which honourable members have raised earlier, sir, it is not enough to make laws, as I've stated. Now, our government knows very well that besides legislation, we have to take sufficient steps to combat these nuisance. Hence, the Union Cabinet headed by Narendra Modi ji on 21/4/2018, while approving this promulgation of Criminal Law Amendment Ordinance 2018, also approved a number of other measures. And those measures are for effective implementation of the various provisions of the criminal laws that are to enhance the safety of the women. One of the important provision being given effect was setting up of fast-track special courts. Now, sir, a centrally funded scheme is proposed, and this will be launched to set up a fast-track special court to exclusively decide on the rape cases and to strengthen such courts where they already exist. Such scheme will cover strengthening of physical infrastructure and manpower for fast-track special courts, etc., in consultation with the high courts and the state government concerned. And, sir, there is also a requirement for the strengthening of the prosecution machinery. For that, the states and union territories are being asked to strengthen, and a dedicated capacity should be created for effective and timely prosecution of the cases for the fast-track special courts by sanctioning of additional posts for public prosecutors, office infrastructure, and supporting manpower. Sir, there is also a requirement for quality of investigation. Many honourable members also had raised this question that the rate of conviction in the cases of rape depends crucially on the quality of evidences collected by the investigating agencies. Therefore, sir, adequate provision of special forensic kits for the rape cases are proposed to be made in all the police stations as well as hospitals where such medico-legal cases are handled, to improve the quality of forensic evidence and thereby strengthen the cases of the prosecution. Dedicated and trained manpower are to be provided for investigation of sexual offences in a time-bound manner. Honourable Deputy Speaker, sir, one or more specialized forensic laboratories adequately staffed and equipped are proposed to be set up in each state and union territories of India to exclusively deal with the forensic needs of rape cases in an efficient and time-bound manner. Sir, one of the important aspects of the investigation of rape cases concerning are the tracking of the accused persons and sharing of the information. Last year, Honourable Home Minister Rajnath Singh ji had launched this very important scheme of crime and criminal tracking network systems in the country. This will ensure that our National Crime Records Bureau will have all the database and a profile of those sexual offenders at the national level and share it with the states and union territories so that the data will be used by the police for verification of the antecedents of the persons for prospective law employers and would-be. It will be a crucial part of the future investigation by any states or any agencies of the country. This will facilitate the entire process. And, sir, to address the issue from a broader perspective, it was considered necessary to create a national mission for the safety of women. Sir, as I have mentioned earlier, besides the special task, fast-track courts and strengthening of the forensic laboratories, building of National Registry of Sexual Offenders, and thereby appointing additional public prosecutors and providing appropriate medical and rehabilitation facilities to victims. These are very important steps which are being taken, and in issues like sensitization of children through appropriate changes in the school curriculum. A media campaign, which Deputy Speaker Sir, you just mentioned, is being thought about. So media campaign and the social awareness and checking the proliferation of the pornography materials which our honourable member had mentioned, online contents, this also will be taken up, sir. And Honourable Deputy Speaker, sir, our Honourable Home Minister Rajnath Singh ji, in the last 4 years, I have witnessed to it in the ministry, have constantly reviewed within the ministry with all the agencies, and the women's safety has been given top priority. And that is why our Home Minister had, for the first time, created a new division in the Home Ministry. And this division is known as Women's Safety Division. This division is dedicated to the safety and security of the women in the country. Besides that, there are various steps taken by the ministry, like special apps and special assistance to the various NGOs, various other organizations working in this particular field. And besides that, sir, the National Mission for Women Safety would lead in the various beneficiary things for all of us to work on for giving a credible response to emerging situation of crimes against women, especially the minor girls. And sir, and some of the consequential effects I would like to mention, which is like today we are making some changes in the Indian Penal Code and in the CRPC. There are consequential effects on the Indian Evidence Act, which I would like to mention some of the important points and important effects which have been made. Sir, earlier, we have heard the situation where the character of women are being assassinated. The women are the victim of the situation, and during the trial process, they are being subjected to various things which are very uncomfortable to the victim and to the society as a whole. That is why, sir, the new clause, Section 53A of the Indian Evidence Act has been changed, and this clause seeks to provide that the evidence of the character or previous sexual experiences shall not be relevant in such cases. And sir, another important provision is, in prosecution for rape, it shall not be permissible to put questions in the cross-examination of the victim as to her character. No lawyer will be allowed to have a cross-examination about the character of the woman. Sir, with that, another important provision under Section 26 of the CRPC provides that rape cases shall be tried as far as practicable by a court presided over by a woman. So preference has been given that the court where the rape cases are tried are to be presided over by a woman judge. These are, sir, very much the victim-sensitive steps taken by the government. Sir, under the Section 154 of the Code of Criminal Procedure, a new provision being inserted is that information given in the rape cases shall be recorded by a woman police officer or any woman officer. So this gives a complete protection to the woman victim. And sir, the provisions in the Section 161 of the CRPC, Code of Criminal Procedure, provides for the examination of witness by police. Now the new provision provides that the statement of the victim shall be recorded by a woman police officer or any woman office. This is also very victim-sensitive measure. Section 164 of the CRPC Act provides. Police officer. Or, yes. For that, the person has to be qualified. You can't put any woman into the job.
In the department, it's my police department that can say.
It is well understood.
Officers, police officers.
Yeah, I understood your point. I understood your point. We will ensure that this kind of sensitive issues are not being followed by anybody who is not competent. The police officer is not just a police person. It's a police officer who is competent to deal with the person, with the cases. That is why you can't have a person who is not sitting in an appropriate authority and we just put him into the job. He must be an authorized person, authorized officer or authorized person. Yes, a competent person. And sir, the subsection, section 5A clause A provides that the statement of the victim shall be recorded by judicial magistrate as soon as the commission of the offence has been brought to the notice of the police. Sir, section 173 of the CRPC also provides that, as I have mentioned earlier, that the investigation of the case shall be completed within 2 months from the date of recording of the offence. That means there is no any kind of chances for any officer to go it beyond 2 months. Timeline, this is very, very important. Sir, under section 197, clause 1 of the CRPC, the new provision that has been brought in is that no previous sanction shall be required for prosecution of public servant accused of the offence of rape. This is very important, sir. And that means how we are putting the onus on the officers, those who sit in the office of authority. They are completely responsible to ensure the speedy justice. Sir, under section 309 of the CRPC, a new section has been inserted. Now, this is a proviso which has been amended to provide for mandatory completion of inquiry or trial of rape cases within 2 months from the filing of the charges, filing of the charge sheet. So once charge sheet is filed, then within 2 months it must be completed. Sir, under section 327, clause 2 of the CRPC.
Filing charge sheet, any time has been mentioned. Filing charge sheet.
Yes.
You are talking from charge sheet to trial, but for filing charge sheet, how many times have been?
This is already, there's an elaborate provision that if any police officer fails to act on any such instances which are serious in nature, there is already enough provision to take action against that police officer. So there is no escape. I would like to also mention here that in last few years, especially last 3-4 years, the numbers of cases have come up. That is primarily because it is now mandatory on the part of the police officer to register the case. Now, what the important changes we have made is not only the registration of the cases, the filing of the charge sheet, the disposal of the cases are all made time-bound. This is very, very important. That is why I would like to appeal the honourable member to appreciate this effort. That is why I have. आप last में
2 months का जो टाइम दिया है, सपोज कि
वो ट्रायल है,
वही नहीं दे पा रहे हैं, जो विक्टिम है वो गवाह देने के लायक ही नहीं है, उसको सदमा लगा हुआ है, तो उस केस में अगर 2 मंथ से ऊपर टाइम जाता है तो उस केस में आप क्या क्लैरिफिकेशन दे रहे हैं?
देखिए, मैं बताता हूँ. मैं अगर sir, let me complete my reply. And in the end, if you have any clarification you are seeking, and I'm ready to give clarification for that. One of the important provisions I want to mention here, the section 327 subclause 2 of CRPC provides now that inquiry into and trial of rape cases shall be conducted in camera. This gives ample scope for the victim to ensure that she gets the justice, because the recording has to be in camera now. So this is something which we are thinking that there should be no loophole whatsoever whereby the accused can get away. Sir, the existing section 357B provides that the compensation payable by the state to the victim of acid attack and gang rape shall be in addition to the payment of fine to the victim. This amendment will ensure that the compensation scheme will be extended to the victims of the newly proposed categories under Section 376AB, Section 376DA, and Section 376DB. And, sir, another important provision which I would like to mention is the existing Section 357C provides that all hospitals, public or private, shall immediately provide the first aid or medical treatment free of cost to the victim of offense of rape and shall immediately inform the police. Through this amendment, the facility of free first aid or medical treatment shall be extended to victims under newly proposed categories of the provisions which I just mentioned. These are very crucial steps which provide immediate medical care to the victim without any financial burden. Sir,
please, madam, please. You continue. You continue. Let you.
Sir,
you continue.
As I had mentioned in the very beginning, I'm not.
Doctor, let him raise the end question. I will allow her.
I'm not dragging this issue to a point where I would like to counter you on some of the points which you have made. In the very beginning, I've said this is not a one-party issue. It is not a question of a concern for one section of the party. It is a concern of the nation, concern of this August House. That is why I would like to request Mr. Prem Chandra also that why are you questioning on the timing of the promulgation and all? In fact, when this promulgation of the ordinance was done, already we have got the information from the state of Madhya Pradesh and elsewhere that they had already booked the criminal under this ordinance. That means it is very useful. It is in fact, and Mr. Saugatara had said that we should have made law much earlier. We know that the parliament has to make preventive steps and preventive laws also. But at times, this house have to reflect the sentiment of this country. So when the whole country, the sentiment of the country is that government must take stringent steps to ensure that the punishment to the crimes of such a heinous nature has to be very, very stringent, very strong, and the government must rise to the occasion. That is why, Honourable Deputy Speaker, sir, though I have many points to clarify to the honourable members, but the provisions which I have read out, I'm sure most of the honourable members will be satisfied and they will support the intention of this government to ensure that our women do not feel insecure in our society. Mahatma Gandhi ji had once made this very important remark which I would like to read out in this August House, that when a woman walks in the street in the night, then only it means that we have achieved full independence. So it is the moral duty of everyone here to ensure that our sisters, our daughters, our mothers feel safe in this, our own very civilized, very ancient nation called India. We will not leave any stone unturned to ensure that the provisions which are made by the government in this Criminal Law Amendment Bill 2018 to ensure that these are put into effect strongly, showing the determination of the government to see that we will provide justice to every single cases of sexual offences against the women. With these few words, I thank Honourable Deputy Speaker, sir, honourable members for supporting this bill, and with this I commence this bill for passing. Thank you.